Air Canada told a judge, in effect, that its own chatbot was a separate legal entity, not responsible for what it said to customers. Here's the twist. Everyone thinks this case is about a lying robot. It isn't. It's about a company that deployed customer-facing software with zero validation and then tried to disown it in court. The chatbot didn't fail. Air Canada's governance did.
November 2022. A passenger needs to fly because of a death in the family. Air Canada, like most airlines, offers bereavement fares, discounted tickets for exactly this situation. The passenger goes to Air Canada's website and asks the chatbot how it works. The chatbot answers clearly, "Book your flight now and you can apply for the bereavement discount retroactively afterward." That's a specific, actionable claim, not a vague gesture, not a disclaimer-laden non-answer, a concrete instruction on how to get a refund later. The passenger books the flight based on that answer. Then, after the trip, they go back to claim the discount. Air Canada says no. Their actual policy has never allowed retroactive bereavement claims. You have to request the discount before booking, not after. The chatbot's answer was simply wrong. Not rude, not confused, not hallucinating nonsense, just wrong, delivered with total confidence on the airline's own website in response to a direct question about money and a family death. This is the setup. A grieving customer did exactly what a company's own automated system told them to do and got denied. What happens next is the part that made this case famous, and it's not the part people expect. Most coverage of this case frames it the same way. An AI chatbot lied, a company got caught, robots strike again. It's a clean, viral framing. It fits the general anxiety about AI making things up. And it's not entirely wrong. The chatbot did generate false information. But that framing treats the chatbot as the actor with agency, as if it decided to mislead someone. It didn't decide anything. It produced an output based on how it was built, what it was trained or programmed to say, and critically, with no human checkpoint validating that answer before it reached a paying customer during a family emergency. Here's the counter-argument you'll hear. Models make mistakes. That's just the current state of the technology. And punishing a company for an occasional wrong answer is unfair to an industry still maturing. That argument has some truth to it in general, but it collapses the moment you ask a simple question. Who decided this system could answer legally and financially binding questions unsupervised, with no way for the customer to know the answer wasn't verified? That wasn't the chatbot's decision. It was Air Canada's. And that's exactly the distinction the Civil Resolution Tribunal ended up drawing, a distinction that gets lost every time this story gets told as a tale about a lying robot instead of a story about a company that skipped a step. When the case reached British Columbia's Civil Resolution Tribunal in 2023, Air Canada's defense was startling in its bluntness. The airline argued it should not be held responsible for what the chatbot said, essentially treating the chatbot as a separate entity, responsible for its own words, distinct from Air Canada itself. Think about what that argument actually requires you to believe. A customer visits Air Canada's official website. There is no other website involved, no third-party plugin, no disclaimer saying this assistant is not affiliated with Air Canada. It's Air Canada's branding, Air Canada's domain, Air Canada's product, answering a question about Air Canada's own refund policy. And the company's position was that the answer it gave doesn't count, because the thing that gave it wasn't quite them. The tribunal did not need pages of legal reasoning to reject this. The tribunal member found that Air Canada is responsible for all information on its website, whether that information comes from a static page or from a chatbot. There is no legal distinction between a brochure and an interactive tool, if both are published under the company's name. The ruling applied a standard concept, negligent misrepresentation. Someone gave you inaccurate information they should have known was inaccurate, you relied on it reasonably, you suffered a loss. Case closed. In February 2024, the tribunal ruled against Air Canada. The passenger was awarded compensation, reported at roughly 650 Canadian dollars in total, covering the fare difference along with interest and fees. It's not a life-changing sum. It's not the kind of number that makes headlines on its own. And that's worth sitting with for a second, because the size of the payout and the size of the implications are wildly out of proportion to each other. $650 is what one customer got back, but the principle established that a company is fully liable for what its customer-facing AI tells the public, with no special carve-out for the fact that it's automated, applies to every airline, every bank, every retailer, every insurer that has bolted a chatbot onto their website to cut support costs. After the ruling, Air Canada reportedly pulled the chatbot from its site, not because the technology got better or worse, because the calculus changed. If you're liable either way, an unsupervised chatbot answering policy questions is a straightforward liability, not a straightforward cost saving. That's the part of the story that rarely makes the headline. The chatbot didn't get smarter after this. It just went away.
So here's where I part ways with how this case usually gets told. The standard narrative is AI chatbot makes mistake, company held accountable, lesson learned about AI reliability. My reading is different, and it's a reading you can push back on if you want. This is opinion, not fact. I don't think this was a failure of artificial intelligence at all. The chatbot did precisely what it was built to do: generate a plausible, fluent answer to a customer's question, based on whatever information and instructions it had. It wasn't malicious. It wasn't even particularly broken. What failed was the governance around it. The decision made by people at Air Canada to let that system answer legally consequential questions about refunds and fare policy with nobody checking its output before it reached the customer. There's a pattern here worth naming. When a company deploys automation into a role where a wrong answer has real financial or emotional consequences, and then something goes wrong, the reflex is to blame the algorithm, as if it wandered onto the website by itself. It didn't. Someone spec'd it, someone approved it, someone decided it didn't need a human reviewing bereavement fare answers. That's not an AI failure. That's a business choosing speed and cost savings over a basic safety check, and getting caught only when a grieving customer refused to just eat the loss.
Now, the separate legal entity argument itself. How seriously should we take it? Here's my take, and again, this is interpretation, not established fact. I think it was a weak, almost lazy legal position, and the tribunal dismantled it without much effort. That matters because a weak defense tells you something a strong one wouldn't. If Air Canada's legal team had shown up with a carefully built argument about reasonable reliance, disclaimers, or shared responsibility, you could say the company at least understood the stakes and tried to engineer a real position. Instead, they argued the chatbot was basically its own thing, legally separate from the company whose name is on the plane. That's not a sign of a cunning corporate strategy to dodge liability. It's a sign nobody had prepared a better answer because nobody inside the company had seriously thought through what happens when the chatbot is wrong. It reads less like calculated evasion and more like improvisation under pressure, a company reaching for the first argument available rather than the best one. And that, honestly, is consistent with the whole arc of the case. An unsupervised deployment, followed by an unprepared legal defense, followed by a quiet removal of the product once the liability became undeniable. None of it required malice. All of it required someone, at some point, to not ask the obvious question before shipping.
Last point, and this is the one I think gets underrated. Is this case actually important? Or is it a $650 footnote inflated by clickable headlines about AI gone wrong? My position is that it's a genuinely significant precedent, precisely because the dollar amount is so small. A tribunal in British Columbia didn't need a landmark multi-million-dollar dispute to establish the principle. It settled the question with a routine low-stakes case. If your company puts a chatbot on your website, you own what it says, full stop. The same way you'd own what's printed in a brochure.
No special exemption for it's AI, it's still learning, it's not really us. That's the kind of ruling that ripples outward quietly. Every company running a customer-facing AI assistant, booking systems, insurance quote tools, banking support bots, now has a citable case showing that the AI said it is not a legal shield. It's a small case that answers a big question the industry had been avoiding. Who's responsible when the machine is wrong? The answer, at least in this jurisdiction, is the company that deployed it, not the model, not some abstract algorithm. The business that decided a chatbot could answer questions about a death in someone's family.